And what's happening in these universal injunctions, again, 40 times in this administration, at least 22 times in the last administration, 64 times in the administration before that, is just disregarding those appropriate procedures to seek this kind of global relief.
I want to ask one thing about something in your brief. You said, quote, and of course this court's decisions constitute controlling precedent throughout the nation. If this court were to hold a challenged statute or policy unconstitutional, the government could not successfully enforce it against anyone, party or not, in light of stare decisis, end quote. You agree with that?
Yes, we do.
If you prevail here, the original executive order had a 30-day period before it took effect. If you prevail here, should there be any pause so that things can happen that need to happen for 30 days or some period of time, or should we not even worry about that?
So we survived until the 1960s without universal injunctions.
That's exactly correct. And in fact, those were very limited, very rare, even in the 1960s. It really exploded in 2007 in our cert petition in Summers against Earth Island Institute. We pointed out that the Ninth Circuit had started doing this in a whole bunch of cases involving environmental claims.
Justice Alito?
You began by outlining what you see as the practical problems that have been created by universal injunctions. If we were to hold that the states have standing, and if it is possible for a plaintiff to get emergency certification of a class, suppose we agreed with you on universal injunctions, but allowed those other two avenues, would the practical problem be rectified to any substantial degree?
Isn't that makes no sense whatsoever.
Respectfully, we believe that.
Well, what was the purpose of the Bill of Peace if not to settle a legal question finally? And if even the Supreme Court doesn't have that right and must invite hundreds of thousands of lawsuits, what are we buying into?
If a set of claims satisfies the rigorous criteria of Rule 23, Rule 23 is the modern analog of a Bill of Peace. We have something very different.
I need all the amici I can get.
Fair enough, Your Honor. So I would say two things about that. The first is it does require reading the history in a way more like I do, which does not create a single bright-line rule that this is never available. Obviously, if someone reads the history as saying it's impossible.
I'm spotting you that for the purposes of my question.
Great.
I'm not granting
I thought you might not, Justice Gorsuch.
But I'm spotting it to you. And I'm just saying, well, okay, what would that look like, and how would that be any different from what we have experienced over the last few decades? To be predecessors of Rule 23, then respond to the point that there is something fundamentally different about a preliminary injunction to a putative class that you found is likely to be certified and likely to succeed on the merits in order to preserve that court's jurisdiction to award ultimate relief to those parties before it, and that's categorically different than a universal injunction.
So starting with the presumption that was different about the Bills of Peace is that they were binding, I think sometimes, it's not clear always, at the end when they were getting to final judgment. I would go back to Grupo Mexicano, to Justice Barrett's point, although that was the high watermark of this equitable originalism, the way the court articulated the test, it focused on 1789, but the actual analysis in Grupo Mexicano focused on 1890 through 1942. And what the court found there is that there were numerous cases expressly rejecting the Moreva injunction, and that was confirmed in the 1970s when England adopted it and said, no, we've never done this before. We are in an entirely different world here. One, the cases that Justice Sotomayor laid out earlier all come from between 1890 and 1942, and they suggest that non-party relief was provided for outside of the class action context. But the fact that we have, I think, these very studied scholars in this rigorous debate about what the bills of peace meant, what the railroad cases meant, I think shows that this is very different in Grupo Mexicano. And for the court to kind of delve into that and adopt the categorical rule that the government is suggesting, I think is certainly an overcorrection. It's a hornet's nest on Article 3, right? It calls into concern APA, class action, a whole sort of things. I would suggest that the court instead focus on providing limiting principles within the confines of the Niken factors of the winter.
Is there a practical?
I don't understand how that is remotely consistent with the rule of law. You know, a system, and I appreciate that you go back to English common law and the Chancery Court, but they had a different system. The fact that courts back in English Chancery couldn't enjoin the king, I think, is not analogous or indicative of what courts can do in our system, where the king, quote unquote, the executive, is supposed to be bound by the law. And the court has the power to say what the law is. And so one would think that the court could say, this conduct is unlawful and you have to stop doing it.
I think the catch me if you can problem operates in the opposite direction, where we have the government racing from jurisdiction to jurisdiction, having to sort of clear the table in order to implement a new policy. A great example of this is in the Schilling litigation, where the military had a military readiness policy. It was universally enjoined by the DDC. It went up to the D.C. Circuit. The D.C. Circuit stayed that injunction to allow that policy to go into effect, and then 1 hour later, a district court on the other side of the country universally.
Can I just ask you one final thing, because this relates to also something that Justice Kagan said. I would think we'd want the system to move as quickly as possible to reach the merits of the issue and maybe have this court decide whether or not the government is entitled to do this under the law. Wouldn't having universal injunctions actually facilitate that? It seems to me that when the government is completely enjoined from doing the thing it wants to do, it moves quickly to appeal that, to get it to the Supreme Court, and that's actually what we would want. What I worry about is similar to what Justice Kagan points out, is that if the government is saying no lower court can completely enjoin it, it actually means that the government just keeps on doing the purportedly unlawful thing, and it delays the ability for this court to reach the underlying issue.
Percolation of novel, sensitive constitutional issues is a merit of our system. It is not a bad feature of the system.
Thank you.
Why can't you get putative class relief in a preliminary injunction or TRO posture?
You mean, in the
get relief
context.
for a putative class in a TRO or PI posture?
I certainly think you can. The court did that recently in AARP. My point is, when the court does that, it's relying on the equitable authority it has to enter that sort of relief, not on the Rule 23 mechanism, because the class isn't binding until after certification, until after final judgment.
If that mechanism is available, whether one way or another, doesn't that solve a large part of the problem in a way that complies with the rules, the problems with universal injunctions that have been identified by administrations of both parties? Go through Rule 23 and do what's needed there, and people are bound then, so that's a wrinkle. But why doesn't that just solve the problem?
Right. So they're not going to be bound until after you get past class certification. So we're talking
I understand that.
And for that reason, I would go to Justice Alito's point earlier that all you're doing is taking the non-party injunctions that are happening now outside of Rule 23 and shoving them into Rule 23. It doesn't address the forum selection concerns. It doesn't address.
And I don't see how you could have a stronger merit showing than we have here. 127 years of Supreme Court precedent, over a century of executive practice, and congressional statutes that codified both into law in 1940 and 1952. And given that strength of the merits and the settled precedent, combined with our nature of harm, I don't think this is a close case for why we need national relief to remedy our injuries.
Thank you. Justice Gorsuch, Justice Kavanaugh, Justice Barrett.
I'm just going to ask you to put yourself in a different frame of mind. Hard to do. Assume something you won't want to assume. But the assumption that I want you to make is that on the merits, which of course you did not take to this court, on the merits you are wrong, that the EO is unlawful. And I want to ask you, if we assume that, how do we get to that result on your view of the rules?
It is very difficult for me to attempt the hypothetical, but I will.
You know, I think that that's the important question in this case. Let's just assume you're dead wrong. How do we get to that result? Does every single person that is affected by this EO have to bring their own suit? Are there alternatives? How long does it take? How do we get to the result that there is a single rule of citizenship that is the rule that we've historically applied rather than the rule that the EO would have us do?
Rule 23 would be one natural path, assuming that a class could be certified, which we might dispute in this particular case.
Well, you might dispute it. And, you know, I mean, I think the question is there a class that's just all children of people who have entered illegally? You know, is that an appropriate class? Can the same thing be done under Rule 23? Or are you going to tell me that, no, Rule 23 has lots of requirements and you'll never be able to certify a class like that?
Rule 23 provides the equitable tools subject to rigorous criteria, appropriately rigorous criteria, to obtain that kind of class-wide and emergency
That suggests to me you're going to be standing up here in the next case saying that Rule 23 is inapt for this circumstance, with this number of people, maybe with some questions that are individual, who knows. So let's put Rule 23 aside, because I got to tell you that does not fill me with great confidence. How else are we going to get to the right result here, which is on my assumption that the EO is illegal?
That would be a profoundly wrong result, but I think what I would offer is that, very similar to Labrador against Poe, what the court should be engaging here is a balancing of the equitable factors as to the scope of remedial relief, not as to the underlying merits. And our contention that this exceeds the traditional scope of equity that's reflected in the 1789 Judiciary Act, we're overwhelmingly likely to succeed on those merits for all the reasons that are stated in our briefs.
I mean, that's a lot of words, and I don't have an answer for if one thinks. And, you know, look, there are all kinds of abuses of nationwide injunctions. But I think that the question that this case presents is that if one thinks that it's quite clear that the EO is illegal, how does one get to that result, in what time frame, on your set of rules, without the possibility of a nationwide injunction?
On this case and on many similar cases, the appropriate way to do it is for there to be multiple lower courts considering it, the appropriate percolation that goes to the lower courts, and then ultimately this court decides the merits in a nationwide binding precedent. You have a complete inversion of that through the nationwide injunctions where the district
General
courts...
Sauer, are you really going to answer Justice Kagan by saying there's no way to do this expeditiously?
Well, I'll refer to my former answers. Rule 23 provides the tools to do so, multiple injunctions.
But you resisted Justice Kagan when she said, could the individual plaintiffs form a class?
That has never been briefed in the court below. I do not concede that we wouldn't oppose class certification in this particular case. There may be arguments that this case is or is not appropriate for class certification. And
if there were a class appropriate for class certification, you concede that that could resolve the question quickly?
Yes, absolutely.
You concede it could resolve the question quickly through precedent?
Yes, absolutely. It could do so. I mean, we obviously...
I'm just going to say just on that point. So, you know, let's say that we're an individual person even. Let's say it wasn't a class. And goes up and gets a ruling from the Second Circuit that the EO is illegal. Does the government commit to not applying its EO in the entire Second Circuit? Or does it say, no, we can continue to apply the rule as to everybody else in the Second Circuit?
I can't say as to this individual case. Generally, our practice is to respect circuit precedent within the circuit, but there are exceptions to that.
Yes, that is generally your practice, and I'm asking whether it would be your practice in this case.
I can't answer because it would depend on what the lower court decision said. So there are circumstances, as I was suggesting, where we think that we want to continue to litigate that in other district courts in the same circuit as well.
Yeah, so that means it's not even the normal time it takes for everything to get up, you know, through the circuit courts and to the Supreme Court. Because even in those circuits that say that the EO is illegal, you're going to be saying, no, you know, we only commit to saying it's illegal to this one guy who brought the suit.
Article 3 and the court's traditional equitable practices provide a range of tools to address that, including a potentially nationwide class action, not a nationwide universal injunction
class
is not
action,
one of those
which
tools.
you say you're going to oppose when that gets challenged.
We are likely to oppose
When
on
that
the
gets
merits.
proposed.
Yes, and if it does not meet the rigorous criteria of class certification, the court should not enter that injunctive relief. That's
Do you think, like,
feature, not a bug.
how about you're not willing to commit to abiding by the Second Circuit's precedent in my – suppose that there's a single person who brings a suit, and it gets all the way up to us after 3 or 4 or 5 years. And we say, we really do agree with those 4 precedents that Justice Sotomayor started with, and your EO is illegal. Is that only going to bind the one guy who brought the suit?
No, that would be a nationwide precedent that the government would respect.
So finally, once it gets to us after 4 years, you're going to respect that.
Yes, and in addition, we may well respect circuit-wide precedent. The Second Circuit, it just is.
And for 4 years, there are going to be like an untold number of people who, according to all the law that this court has ever made, ought to be citizens who are not being treated as such.
And in the meantime, any of those plaintiffs could have come forward and sought, preliminary injunctive relief, and they could do so on a class-wide basis. There are tools to address this, but the universal injunction, which is issued here 3 days after the executive order was issued, is not one of those tools.